If you go through the different flavors of pre-pack, one is the traditional where you don't try and seek any out-of-court exchange in an effort to avoid a bankruptcy. You just go through, negotiate with your creditors and reach the certain voting thresholds and then file the Chapter 11. This is probably the most common prepackaged Chapter 11 in the United States. The next one is where you have sort of a carrot and stick approach. You're trying to achieve some out-of-court consensual agreement that generally needs to meet some certain threshold, 80, 85, 90% participation by the note holders. If you're able to achieve that, then there's no reason for a prepackaged Chapter 11. The stick in that instance is that if you're unable to achieve certain thresholds, but you get so far, then you'll go ahead and commence the prepackaged Chapter 11 in order to, again, grab the holdouts and move the restructuring forward. The least common, but still out there, at least there's only one instance I can recall in Idaho where it occurred, where you have some solicitation of the votes, which is the last one, the partial prepack, where you solicit some votes of significant creditor parties, file the case, and then commence the voting for the balance thereafter. As I noted earlier, and on the right side of the screen, there's a 24-hour ultrafast prepacks. This is simply an expedited prepack where the bankruptcy rules have facilitated the ability to file for bankruptcy, and sometimes within a matter of less than 24 hours or even slightly longer, you can exit bankruptcy with a confirmed plan. This is where there can be significant objections from the United States Trustee's Office, which is the office that is governed with calling the balls and strikes of bankruptcy cases in the United States, will come in and potentially and most likely object on due process concerns in that there's insufficient time for the U.S. trustee and other creditors to provide an insight, objection, response, or even analyze the situation to make sure that everyone's being treated fairly and that the process being deployed is in the best interest of all creditors, not just necessarily the secured creditors who may be the only ones impaired and entitled to vote in the prepackaged Chapter 11.